sing in exultation, sing all that
Let us adore him. Oh, come, let us adore him. Oh, come, let us adore him, Christ.
Welcome to The Voice, your community legal information program, and season's greetings to all of you who are celebrating during this period. I'm Jennifer Obaseki, and I'm going to be talking to you about the legal issues affecting us this year and many of the common problems people have had over 2017. Before I go into what the year has brought for many of you, the issues, the ups, the downs, I'll start with where we are at the moment with Brexit. As you've seen, Theresa May has come to an agreement finally on the fact that those who are here from other European countries exercising their treaty rights will not be asked to leave as soon as the end date comes. And most recently in Parliament, she was not allowed to fix a firm date on that. So you have to, as you're here, exercising your treaty rights, remember to please take action and apply for your registration. Not just for yourself, but for your family. And if you're in between jobs, out of work, on maternity leave, or in short-term contracts, still apply if your intention is to stay in the United Kingdom. And apart from the immigration elements that Brexit may affect, it's also important for those of you who may be in the consumer or service industry to look at how Brexit might affect you. Whether you will need to review some of your terms and conditions, your contracts, and maybe you might need to think about engaging in joint ventures with companies who are trading on the continent. Many people, rather than sit and be unsure or unprepared, it's better that you have your options open, and signing things like joint venture and agency agreements will be there as maybe backup. If the agreement that the UK comes to is not favourable for you, at least you will have a branch or a way through to continue your goods and services on the continent without hitting barriers through a sister or a joint venture company that you may join up with. And again, as I've said, it's very important that you keep your eye on information regarding the talks if you are affected as a business user or as a consumer service provider. Reason being, you don't want to be caught short. And if you're also in the business area or field, again, if you have migrant workers, looking at those who have to move between the member states, making sure that if they are visa nationals, that you may apply for them to already secure their Schengen visa so that there will be no delays in their ability to move between places as if they have come from outside the EU into the UK to work and have going in onto the continent. It's better that if they are moving around Europe to make sure that they secure those types of visas. But over the year, it's been very busy. We've seen a lot of people with different issues. One of the major issues that we have noticed is those who are going to renew their papers not being prepared. And during one of the earlier shows, I always said, be prepared, preparedness, and start in time. The Home Office always looks at applications within 28 days of the date of expiry. If you put it in too early, they won't look at it. So there's no point putting it in months and months before your leave is due to expire. Not only that, they might send it back to you, they might lose your documents, it might get lost in the post. So at least 1 month before your documents are due to expire, put your application in. All the more reason to do so is because lots of employers are stopping people from work during that time when your application is being assessed and reviewed. This is causing catastrophic problems, especially for those who are working in the security industry with SIA badges, those who are working in other jobs such as care, where they're having to go through DBS checks because it flags up on the system that this person's leave to remain is due to expire. And therefore, often they're not allowed to continue going into work, they're being suspended. If this is happening to you and it's being done unreasonably, it may then lead to being an employment issue. So be very careful on putting your documents in on time so it doesn't affect your work, that you can receive an acknowledgement from the Home Office in good time. Also be able to go and do your biometrics so your application is considered within a reasonable period. Don't forget also that the standard period for the Home Office to look at your application is actually 6 months. That's what's called their standard working time. Now, which is wonderful now, you can check the progress of your application online, which is very, very good. And also you can do so by phone. But what we've noticed is that at times telephone, people are not so keen to give you specific details. So it's always good to try and put your email inquiry in. The other thing is sometimes the email inquiry may not be accurate, but that's been, I would say, only a few percentage of the time, not as much as one needs to stress. But now and again, the information may not be absolutely accurate, i.e., for example, they may say they've got a decision on your case and you might wait 2 weeks, not receive anything, then go back and see a decision still pending. So initially the first information given may not be accurate. So if you're dealing with issues yourself, having things prepared, reviewing your application, reviewing your supporting documentation, then putting it in on time and following up via the internet, via the phone on the progress of your application is important. And those are things you can do using the .gov website. But if you have difficulties, please feel free to call the number on the screen and then we'll be able to help you. Alternatively, you can try to contact a solicitor in your area or a member of the Immigration Advisory Board, and that's the OISC. Other things that have been, again, common issues, still people falling foul of the 7-year rule. There is no automatic right for children who have been here for 7 years to stay. We've gone over this so many times, but if your child has been in the UK for 7 years and there are very short and difficult barriers for them to re-enter their country of origin, that is the country that their parents have come from, then you would be wise to make an application after receiving advice. So you can only make the application and be sure that it's going to be successful if you can prove what those barriers are. And barriers are a lot more than food and language, because it's expected that you will support the child in going back. So barriers are things such as health barriers. So if your child's suffering with an illness, or if your child has special needs, or if your child has suffered a level of trauma due to an incident, then you would have to present evidence of the same and then put it in with your application. But be very wary and take advice, because it has been proven time and time again that barriers have to be clear and real and insurmountable. In other words, they can't be things that the child is going to overcome with support and with you being there as the parent to do that, because it's expected that you as parents will go back. Other things you need to be aware of are things like the cost of the applications, because people, again, don't save up enough, coming at the last minute, and really it puts a lot of pressure on themselves and on their family units, as well as on the solicitors if they're not able to deal with it and then send off rushed and let me say pre-baked applications. You need to have something that is going to be prepared properly, having spent the right amount of time dealing with the form, preparing the evidence, the submissions, making sure that you're going in under the right category. So again, making sure that you've saved up the right amount of money to make sure you meet the cost of your application for yourself and any dependents. It's necessary. If you don't send off the payments for the application fee and for the NHS fee, your application may be refused, deemed invalid, may slow things down, and that's something you don't want. It is difficult to meet that cost of the application fee, as I've said, as a community, Afro-Caribbean community, Asian communities that are affected by this. It's really important that you let those representing you in government be aware of the fact that it's causing a lot of hardship to a lot of people. And families are having to often make decisions as to who puts in their application. Should it be the main applicant? Should it be just the parents and not the children? our advice and my advice to many people in this situation that are trying to make this decision is that you should look at who needs the application, who will be penalised if they don't put in the application. So that's usually the parents. They need the application in order to continue their work obligations and commitments. But children, if children are not travelling and they're near to the age of 10, then you might need to say, look, if this child is 8 going to be 9 or 9 going to be 10, we may need to save that money towards their application for naturalisation. So very, very important you take advice if you don't have enough funds on who should put in an application and who shouldn't. Going on from that, then it's important to also look at children who do qualify for naturalisation. So these are children who have been born in the United Kingdom and they also have not left the United Kingdom for over 10 years. So when you're preparing these types of applications, you have to be able to prove that the child has not left by providing a level of documentation. And I always say in the English legal system, the best way to describe it is show and tell. So you have to show the evidence in order to convince the person that's assessing whatever it is you're applying for or appealing for or requesting. And then you have to also make your submission by telling your story, explaining why you qualify. So the show and tell element go hand in hand. It's not just filling out a form and saying my child has been here for 10 years, but it's a case of actually outlining, providing the evidence, addresses, schooling, other reports, etc., to prove that the child has not left the shores of the United Kingdom. And then also finding 2 people that can validate that you are a person of good character and the child is too. We've also met people who have a common problem of having convictions for themselves when dealing with their naturalisation and leave to remain applications. So now the government really does do the background checks in detail. Once upon a time, fees were low, background checks were not done thoroughly, but those days have gone, I can reassure you. So if you've got convictions that are not deemed spent, then it may affect your applications for leave to remain or for naturalisation. And one of the common problems that we've seen since December 2015 is even when people have been deemed of good character and qualified for their indefinite leave to remain, they've not been deemed as people of good character and qualifying for naturalisation. People will say, why is that? How can I be of good character and qualify for my indefinite, but then seen as not being of good character when applying for my naturalisation? And it's because there are 2 different types of tests, 2 different standards of tests. The standard that's done for indefinite leave to remain is lower. That done for naturalisation and the acquisition of British citizenship is much higher. And it's unfortunate, but they do look at periods that have been spent working without correct documentation. So what you need to do if you know that you've been in that position is be prepared to outline how you sustained yourself during the time that you were not documented, so that it shows that you've not done anything like break the law or work illegally. So you find people who supported you during the time that you were not documented to outline how they supported you, whether it's with food, accommodation, even if they supported you emotionally and can attest that you're a person of good character. That will stand in good stead when you're making your application. But again, if you have difficulty, because these forms are long and complex, you can get support and advice in making these applications. Then going on from that, if we look at other issues, many of the other issues came around family units where they had separated. So if you can no longer find the person that you got married to that gave you your leave to remain, or if there's issues such as domestic violence, it's important that you seek help on whether you need to actually change the nature of your application for leave to remain, or whether there is a provision for you to make some other alternative application. So for example, if you're the victim of domestic violence or spousal abuse, or you've been in a relationship that is akin to marriage, and when I say that, that's a relationship that's more than 2 years in duration. If you've been in such a relationship, managed to get your application in and you've been settled, but however, along that line, things break down, what you need to do is you need to take some advice. You may have to switch into an alternative application. And depending on whether you have children, depending on the level of evidence, if there's been physical violence or domestic violence or any other type of abuse, then you may have to alternate the type of application you make. And just touching on that, abuse is not always physical. It's not always about whether you were hit, whether you were hospitalized, whether you called the police. Those are important factors. And if that does happen to you, one, you should seek help. You shouldn't put yourself in a position of danger. Two, you can't beat yourself up or put more pressure on yourself if you did not get sufficient advice or if you didn't report matters to the police. But what you can do is make sure that you are protected. So I always say this, and I say to people, if you're dead, I can't help you. So the one thing you must do is protect yourself. But if you're in a position where you're completely dependent on another person, you're undergoing abuse, please try to realize that there are organizations out there that can help you. There are solicitors out there that can help you. So number one, you can seek help from social services. You can seek help from specialist charities that help women, men who are suffering domestic violence. And I did mention that abuse is not always physical. It's not always physical. So it might be emotional abuse. It might be the case that your spouse, your partner, your husband is asking you for your wage slip at the end of the month, not allowing you to access finance, not treating you well, leaving you wholly dependent and partially enslaved. This type of treatment is equally abuse. It may also be emotional abuse, where you're receiving verbal attacks all the time, being degraded. All of this is something that is not acceptable treatment. So it's hard to document some of it, of course. The emotional abuse is not easy to document, financial as well. But what is important is if you are able to get witnesses, if you are able to get recordings, and if you do report it to agencies, as I've mentioned in the past, charities, support groups, social workers that can help, then it may give you further evidence to bolster any other alternative application you need to make. So divorce, again, may affect your application. So you have to be very clear that the obligation is for you to tell the Home Office if your situation changes. But before you report that, as I've said, very important that you do take advice. Very, very important that you do take advice. But you can be deemed as not complying with the conditions on your leave to remain if you do not advise the Home Office of a change in your situation. Now, very important again, that if you're given conditions, that you maintain them. And conditions can be things such as reporting, residing at a particular address, again, reporting to a particular immigration officer, police station, immigration office. These can be conditions. Also, sometimes that you actually sleep in a particular address and are available for doorstep production might be a very arduous condition, but it can be used by immigration for bail conditions and other things. So complying with conditions, very, very important. Working hours are conditions that can be placed, the ability and the right to work on conditions. So again, if you're caught falling foul of these, it can usually be put down and affect your any further application that you make. Now, we've gone over quite a lot of immigration. There's still the issue, as I said, of divorce, being ready. If you're a parent, again, that's another area where the Secretary of State pulled back some powers through legislation this year. What they did is they made it a level of discretion for them to offer citizenship to babies that are born. And the reason they did that is they realized that there was a very large number of British-born children that were leading to their parents acquiring status. So you had, in some circumstances, the Secretary of State asking for DNA evidence, and that going forward has become quite normal. But when going to register a child, it was not very commonly used until the change in legislation that has been put in place that says that the power to give the nationality to the child or the registration to the child is discretionary. Within immigration, there's always been a level of discretionary power, but that being bestowed to the child's nationality at birth was almost a given until the legislation was pulled back recently. And if you are asked to give DNA evidence on behalf of a child, but unfortunately, if there is a different father that has been the biological father to the child to the one that's registered on the birth certificate, or if there's any other type of complication, then very, very important that you take legal advice, because a parent is one who asserts the rights not just biologically, but also may do so through court. So if there is an issue, if you are parenting a child that is not yours biologically, that is a stepchild, or one that you have agreed to parent, or one that you thought you were the biological parent and you turn out not to be, then you can make an application to court for parental rights and make a child arrangements order, or you can even by consent have a parenting agreement that is confirmed, that thereby once you are confirmed as somebody who has a relationship with a child, who can show that they are having parental responsibility over a child, may lead to you making an application and supporting your application to the Home Office for leave to remain. So if we run forward a little bit more, again, I spoke about social services helping people. Often and still, unfortunately, we do see people that have children going to social services for help, even when they're not documented, and being turned away. That should never happen. There is a very severe and important duty on social services to assess you and your child before they turn you away. And if that assessment is not even done, then that is a breach in their responsibility and obligation to you. And just to backtrack on that in relation to immigration, before any decisions are made by the Secretary of State, there is a very onerous obligation on them to assess the needs of any child that you're related to, or any child that may be affected by your immigration decision. So sometimes it may be very important for you to get an independent and private social worker to carry out an assessment on your family. I know these can be expensive, but if you are already involved in social services, you may ask them to write an addendum to support you. But at the same time, if you're not involved with social services, but you have an immigration issue and you have children, it may be very important for you to have that independent social worker's report, so that it is considered expert evidence as to how a child will be impacted on an immigration decision if it's made in relation to your family. So going on to social services, many a times, again, they threaten to separate children from parents, outlining that they can carry out their obligation to the children and not the parents. And that should not be the case unless there's very good reason to do so. So if you are facing that kind of situation, you must find a legal advisor that deals with either community law or housing law and or children law that can advise you substantively on the issue. It should not be a case that you're being separated, but often that is used as a threat by social services, unfortunately. And going on from social services, we are finding a lot of families are having intervention issues. That means where either there's an allegation of harm towards children and the local authority feels that they need to step in order to protect the child, either by asking the parents to come to an agreement not to either touch or carry out a particular action with the child, or actually making the parents sign a Section 20, which is like a consensual agreement in order for them to take the child away from the family home while they investigate what's happening. Quite honestly, a lot of the time, a lot of, I would say, pressure is put on the parents to sign documents without taking legal advice. And one of my own personal policies is I don't sign anything on the same day it's presented to me unless I have to. And one of the things that you should do is take legal advice. You must always cooperate with social services, because what they look for is they look to see that a parent has nothing to hide. They look to see a parent is cooperating and they can deal with the fact that there is an inquiry, an investigation, an allegation. But what must happen is that there must be a balance. If you're innocent, obviously you want to prove that innocence, and you don't want to feel subject to agreeing to something just because somebody's threatening to take away your child, or just because somebody says if you don't sign it, it's going to be much worse. And again, we hear different things. So, very important, if you are under pressure by local authorities due to allegations, maybe there's been an incident in the home and you're being asked to attend for interview or etc., that you actually get some substantive legal advice. Now, I've run through different topics, tried to do a bit of a recap, and we've come to the end of the show. Again, if you need any help, do call the number that you see on the screen. You can get in touch with Ben TV and they'll be able to direct you, but also the Law Society can put you onto a solicitor that's close to your home. Thank you very, very much for spending time with me, and I hope you enjoyed the show. Have a good day. Bye.